Italian intellectual property appeals. Today we will talk about preliminary injunction in Italy. Proceedings dealing with intellectual property rights are tried in Italy before one of the 20 IP specialized courts. The proceedings are commenced filing an application for preliminary injunction before the court. Jurisdiction is established based on the place where the defendant has its registered office. When there are more than one defendant, all of them can be sued before the court competent for one of them. Alternatively, jurisdiction can be found where the infringing items are sold, are commercialized, and this allows some forum shopping in the Italian territory. As we have said, the applicant files an application and some documentary evidence with court. In almost all the cases, I would say 95% of the cases, the application is not granted ex parte. It is common belief in the Italian IP world that it is fair when a preliminary injunction is sought to hear the reasons of the defendant. So unless exceptional circumstances apply, the order is not granted ex parte and the judge schedules a discussion hearing where both parties will show up and argue their defenses. The defendant can submit a written defense prior to the hearing. Sometimes this deadline coincides with the same date of the hearing. After the examination of the written brief, the judge allows the party to briefly propose their argument in an oral discussion. If no other evidence is required, the judge reserves his or her decision, which will be issued in a few weeks. If other evidence is required, further hearing is scheduled. When a patent is enforced, the court is very likely to appoint a court expert. In fact, Italian judges do not have technical background and therefore need to rely on an expert opinion to establish validity of the patent and infringement. Preliminary injunction proceedings last 2 or 3 months if it is enforced a trademark or a copyright or an industrial design, or if it is a case of unfair competition. When a patent is involved and there is the need of a court technical examination, the proceedings can last 6 or 8 months. We are talking about the first instance proceedings. If a preliminary injunction has been granted in first instance, the filing of an appeal does not automatically stay the effects of the preliminary injunction. The appeal is dealt by a panel of 3 judges of the same court that granted the order that in first instance is granted by a single judge. It is worth noting that there is no need to commence ordinary proceedings on the merits after a preliminary injunction is granted. Therefore, it is possible for the defendant or for the plaintiff to commence ordinary proceedings, but also it is possible that the injunction will stay even if the party do not propose ordinary proceedings on the merits. And also for these reasons, in Italy, preliminary injunctions have become a very effective tool of protection for intellectual property rights. DLA Piper Italy have a substantial experience in intellectual property litigation. We also benefit from the fact that over 400 lawyers throughout the world are IP experts in our field, and so we can provide, especially in multi-jurisdictional litigation, a coordinated service to the multinationals. Please stay connected to Lawyers Monday.